Hi, Lee Phillips here. I want to talk about clearing title or quieting a title. You have a piece of real estate, you've got a deed to the piece of real estate, but somehow the deed's not right. The guy who gave it to you, when he got the piece of property, it was deeded to him as Robert E. Lee. When he gave the property to you, he only signed the deed Robert Lee. Is that the same guy? I don't know. So your title is flawed. It has a cloud on it. The property description in this title and the next title aren't the same. There are just tons of reasons why you would want to quiet a title or to clear a title somehow. For example, Dad died and the sister lived in the house for 20 years. Now we're selling the house. Well, the deed's in Dad's name. Dad's not there to sign. Oh, go through probate. No. Probate, you always have to file within X number of months after Dad dies. A year, 9 months, 2 years, depends on the state. So we can't do probate anymore. The only thing we can do is we can go to court, and in that case we can have a determination of heirs, or we can have a quiet title action. If the deed is flawed, we're going to have to clear the title. We're going to have a quiet title action from the court somehow. Once the court says, no, everything's cool, yeah, there's this flaw in the chain of title, but we're going to correct it, and according to the law, according to the courts, we now have good title. Now we've cleared the title. Now we've taken the cloud off the title. We have a clean title. The title insurance company will give us the title policy. I can get the mortgage because I've got the title policy. You can do all of this stuff. So it isn't unusual to have a flawed deed somehow. And living revocable trusts, I get flawed deeds quite often because there are 3 things that you have to have in that deed when you move it from you to the living revocable trust. If you don't have those 3 things, you're in trouble. You got to have the name of the trust, you got to have the date of the trust, and you've got to have the trustee's name. So it's the Ugly Light Trust. It's the under agreement, September 3rd, 2006, John Doe, trustee. If I don't have all 3 of those elements, and I see 1 or 2 deeds a year where the lawyer has prepared it, and he didn't put under agreement, such and such a date, or he didn't put trustees. So those 3 elements have to be there in a deed that's gone to a trust. And I see that screwed up often. And we have to go to court. We have to get the court to give us a title. Say, yep, we understood. Yep, you guys screwed up. Yeah, we know it's supposed to be in this living trust. It's supposed to go to these people. And the court gives their stamp of approval on it. Then I have a clean title. Until then, you can't sell a piece of property. It doesn't work. This is all in the probate court process. So you're in probate court, even though you're just quieting the title or determining the heirs or whatever it is. This is all probate stuff, indirectly or directly. Probate courts are huge. We have a video out on probate, and you can look at that. This is Lee Phillips talking about quieting titles or clearing the title.